starting off with the history and establishments of High Court. So High Court was established under the Federations of Malaya Agreement 1948. Back in the day, there are three kinds of High Courts of coordinate jurisdictions. The first one is High Court in Malaya, the second one is High Court in Sabah and Sarawak, and the third one is High Court in Singapore. But unfortunately, due to the separations of Malaysia and Singapore on 9 August 1965, the High Courts in Malaysia only remains with two High Courts, which is High Courts in Malaya and High Courts in Sabah and Sarawak. Moving on to the organization structure of the High Court. The High Court in Malaya and the High Court in Sabah Sarawak are each presided over by the Chief Justice of the respective courts, or known as Chief Judge by now. Initially, in the High Court in Malaya, there consists of Chief Judge and not less than 2 and not more than 4 other judges. Meanwhile, in the High Court in Sabah and Sarawak, consists of Chief Judge and not less than 4 and not more than 8 other judges. You can see the charts that we have provided to all of you guys. The first one is about the overall High Courts in Malaysia. The second one is the High Court in Malaya. And the third one is High Court in Sabah and Sarawak.
Assalamualaikum warahmatullahi wabarakatuh. I will be talking about the functions and the operations of the High Court. There is 3 jurisdictions of the High Court, which is original, appellate, supervisory, and revisionary. For original, which means the power of the court to listen to a case for the first time. The High Court has unlimited jurisdiction over civil and criminal matters. For civil, the High Court tries cases where the amount involved exceeds 250,000 ringgit. As for criminal, the High Court tries cases where the offence is punishable by death or other serious offences.
Next is appellate jurisdiction, which is the power of the appellate court to review, amend, or overrule the decision of the trial court. The High Court has the power, can hear appeals from subordinate courts in both civil and criminal cases. For civil, the High Court can hear appeals where the amount of dispute is less than 10,000 ringgit. And for criminal, the High Court hears appeals from subordinate courts according to any law enforced within territorial jurisdiction. Next is the revisionary and supervisory jurisdiction, which is the power of superior courts of general superintendence over all subordinate courts. Section 31 Courts of Judicature Acts 1964 gives the High Court the power to revise criminal proceedings in the subordinate courts. Section 32 gives power to call for and examine the record of any criminal proceedings before any subordinate courts to satisfy itself with the correctness, legality of any decision recorded or passed. Then there is also Section 35 that empowers the High Court, in the interest of justice, either of its own motion or any interested parties, to call for the recordings of any proceedings, civil or criminal, to give subordinate court directions for the further conduct of the case.
So let's move on to the third part, which is the legal personnel. So first, our team has chosen to talk about the High Court Judge. So we're going to explain about you the qualifications of the High Court Judge and also code of conduct of the judges itself. So let's begin. So firstly, qualifications. A person is qualified to be appointed as a High Court Judge or Judge of a Court of Appeal or even Judge for Federal Court if he is a citizen of Malaysia. So it doesn't mean that only citizens of Malaysia, it depends on the court itself. So if your court is in Malaysia, then all the judges must be a Malaysian, must be a citizen of Malaysia. So if the court is in other countries such as like Indonesia, so the judge must originate from Indonesia. They cannot be a citizen of other country and then want to be a judge in other countries. So the second criteria is that for 10 years preceding his appointment, he has to be an advocate of any of those courts, which means the Court of Appeal, the Federal Court, and also the High Court. So in order for you to be a High Court Judge, you have to practice as a lawyer first for 10 years, minimally for 10 years. So after that, then you are qualified to be a High Court Judge. The second criteria also mentioned, even if you aren't a lawyer before you want to be appointed as a High Court judge, you can also be appointed as a High Court judge by other means, which is if you are the member of the Judicial and Legal Service of the Federation or Judicial and Legal Service of the state, you can also be elected to be High Court judge. So if you are a lawyer, you are a practicing lawyer minimally for 10 years, or you are the member of Judicial and Legal Service of the Federation, or you are the member of the Judicial and Legal Service of the state, either these three, you can be elected to be a High Court judge. So these are the three occupation or the three works that you have to do minimally for 10 years before you are elected to be a High Court judge. So let's move on to the second part, which is the Code of Conduct of the Judges. So basically, what is Code of Conduct of the Judges? It's actually the do's and don'ts of the judge, and also all the regulations that they have to follow while working as a judge. So firstly, under paragraph 5, the judge shall uphold the integrity and the independence of the judiciary, which means a judge shall exercise his judicial function independently on the basis of his assessment of the facts and in accordance with his understanding of the law, free from any extraneous influence, inducement, pressure, threat, or interference, direct or indirect, from any quarter or for any reasons. So which means that a judge cannot make a decision for a case other than his understanding of the law itself, of the factors such as like other people influences, bribery, and opinions that doesn't based on law shall not be exercised during his working days or working years as a judge, because a judge function is all exercise his whole integrity to make decision of the case, because that punishment will be punished on someone, and we want that punishment to be fair at the very first place. Next, we'll move on to the paragraph 8. So, number 3 of paragraph 8 stated that a judge shall refrain from any conduct as a member of any group or association or organization, or participate in any public discussion which, in the mind of a reasonable person, may undermine confidence in the judge's impartiality with respect to any issue pending before the court. Number 3 of paragraph 8 means that a judge cannot be or participate in any group such as like NGOs or any activism, or even like any activities related to public and also public discussions, because later on, let's say that if the judge take a certain cases and then made a decision, so if the judge participate in this kind of actions, in this kind of activities, it will raise doubt and will cause people to argue because of his decision. So let's say that this judge participate in certain activism activity. So and then some people will argue about his certain decision on certain cases, saying that because of that judge joining this and this, so that's why he made the decision like that. So that's why he is influenced by his group. So that's why we wouldn't want a judge to participate in this kind of actions, because it can make the citizens argue and have doubt to that judge, saying that he is influenced by his actions and brought the influences to the making of his decision of certain cases. Because meanwhile, on paragraph 5 saying that a judge shall make his decisions solely on his understanding of the law. So that's why the number 3 of paragraph 8 stated like that. So let's move on. So number 4 in paragraph 8 stated that a judge shall not participate in any political parties or activities or any political involvement, and shall refrain from any conduct which may give rise to an appearance that the judge is engaged in a political activity. So why a judge is restricted to join a political party or to be involved in the politics as a whole? Because we know that politics is a very sensitive issue, and noted that not just normal citizens or not just normal people that go to the court, even politicians also are normal citizens. So that's why politicians also go to the court. So let's say that if the judge is a participant, of a member of a certain political party, and when a member of that political party has against the law, and when the judge has to take the case of that particular politicians, so again people will raise doubt and people will argue about his decision, saying that, oh, you made that decision because he is from your he is a member of your political party and you're also a member of a political party, so that's why you made the decision like that. So we wouldn't want that kind of argue coming from our citizens. We want them to see that the judge has made the most fairest decision based on the law itself. So to avoid this kind of like problems arise, this kind of issue arise, so that's why the judge is restricted to participate in any political movement or politics as a whole. And other factors is that this political issue also can bring unnecessary influence to the judge. So we wouldn't also want people to see that this influence actually had participated in the decision making of the judge in certain cases. So it's actually a very good thing for a judge to not involve in any political issue, to avoid hassle and also raising doubts in the country. So one of the case that was heard in High Court, which is soldier to hang for stepchild's murder. So this case began when the witness, which is the mother herself, witnessed that her baby was taken out by her husband, which is Shahrul Izwan, with her intestine coming out from the private part. So when asked to Shahrul Izwan, how did that happen? Shahrul Izwan, which is the accused, didn't say anything and stated that he did not do anything. He is sorry to the baby, but then he did not say that he is the one which caused the intestines from coming out from the baby private part. So then the accused told the wife to bury the baby somewhere else, and the wife had no choice but to follow, because her husband himself said that if she did not follow his instructions, he will murder her other children from previous marriage that is located in her parents' house. So that's why the wife had no choice but rather than to be an accomplice in the case. Later on, the grandfather came to pay them a visit and to pay the baby a visit because they missed to play with their grandchild. But then the wife stated that, oh, the child went missing. But then it was really weird, because even when the child went missing, they didn't do anything about it. So her father, which is the grandfather of the baby, felt really weird and said that they should make a police report. But then the wife still begged the father not to do so. So hence, without taking account of her daughter's statement, he immediately lodged a police report regarding the missing of his grandchild. So the court that heard the case is the Taiping High Court on 18 September 2006, and in Court of Appeal on 24th March 2010. So the parties involved in the case in High Court is Shahrul Izwan, which is accused, versus the public prosecutor, and in Court of Appeal the public prosecutor versus Shahrul Izwan. And then later on, the decisions that was made by both court. So Taiping High Court has punished Shahrul Izwan for death penalty because he has murdered the child. But later on, the accused, which was Shahrul Izwan, has made an appeal, and the appeal was accepted by Court of Appeal. So the sentence was reduced to 18 years of imprisonment, mainly because they accepted the statement that was made by his wife, saying that the wife heard her husband said that he has no intention of killing the baby. So that's why they reduced the sentence.
Next case dealt by the High Court is the Tafiz Ittifaqiyah case. Parties involved in this case is the public prosecutor, the High Court judge, Dato' Azman Abdullah, and the 16-year-olds. The decision of the court was that one of the 16 years old was found guilty. The summary of the case is Magistrate Siti Raziah Kamaruddin made the order for the case to be transferred to High Court from Magistrates Court because it was decided that a more suitable punishment to be imposed upon the accused were out of the magistrate's jurisdiction, and the duo was seen leaving Jalan Datuk Keramat on September 14th, 2017 based on the CCTV that the source of the fire is from a lighter, and it was shown later on that one of the suspects had placed the lighter allegedly used during the fire in his bedroom.
The 2nd of July 2020, High Court Kuala Terengganu has sentenced 3 men with life imprisonment and whipping. They were found guilty of kidnapping for ransom of a young woman. They were charged under Section 3 of the Kidnapping Act 1961. Hi, Assalamualaikum warahmatullahi wabarakatuh. Just now, you just watched a video that related to my case. And this case is one of the many cases which High Court has dealt with. So the title of my case is Trio Gets Life Sentence, Whipping for Kidnapping. So the court which heard the case is High Court Kuala Terengganu, and the parties involved in this case is Deputy Public Prosecutor v 3 defendants. The first one is Zairul Nizam Muhammad Noor, the second one is Khairul Anwar Musa, and the third one is Abdul Hadi Abu Bakar. So the 3 of them were charged under Section 3 of Kidnapping Act 1961, and the decision made by the court is that the 3 of them were found guilty and they were sentenced with life sentence and whipping. So Zairul Nizam will be getting 7 stroke of cane, meanwhile Khairul Anwar and Abdul Hadi will be getting 5 stroke of cane each. And last but not least is the summary of the case. So on 2nd of July 2020, the trial has begun for these 3 defendants. So they were charged under Section 3 of Kidnapping Act 1961, which provides to death penalty or life imprisonment with whipping. So during the trial, the defendants unable to make a defense for themselves, and their statement were merely in denial, and they are also unable to provide an exact location where they were during the kidnapping occurred. So Judge Dato Abdul Wahab has met up the sentence because he believed the prosecutor has established a prima facie case, and their respective counsel able to plead for life imprisonment instead of death penalty because they claim that the 3 defendants has been remorseful and they have learned their lesson during the remand period.